The present appeals assail the correctness of the judgment and order dated 15th November 2018, whereby a division bench of the High Court of Madhya Pradesh, bench at Indore, affirm the death sentence awarded by the trial court and at the same time dismissed the appeal preferred by the appellant against his conviction and sentence awarded by the trial court. Full stop para. The present appellant was charged for offence under section 363, 376 bracket 2 next bracket small I of the Indian Penal Code, section 5 bracket small m, 6 of the POCSO Act and section 302 and 201 capital IPC. Full stop. The trial court wide judgment dated 17 May 2018 convicted the appellants for all the offence and awarded the following sentence as against each of the offences. Full stop para. The appeal preferred by the appellants was dismissed by the High Court and the death reference forwarded by the trial court was affirmed as already noted above. Full stop para. During the pendency of these appeals, the appellant moved an application being capital IA number 43271 of 2019 claiming juvenility and consequently the benefits available under the provisions of the Juvenile Justice Care and Protection Act 2015. Full stop. The application was apparently filed under section 9 bracket 2 of the 2015 Act. Full stop. This court, wide order dated 28th September 2022 require the trial court to submit its report after due inquiry as to whether the appellant was a juvenile on the date when the offence in question was committed. Full stop. The order dated 28 September 2022 is reproduced below para. Pursuant to directions issued on the last occasion, certain reports documents have been placed on record. Full stop para. Without commenting on merits or demerits of the rival submission, we direct as under A bracket. The copies of the records be sent to the concerned trial court as early as possible in physical form as well as in a digitized form. Full stop para B bracket. The accused shall be produced before the concerned trial court within a week's time. C bracket. The trial court shall endeavour to consider whether the appellant was juvenile as on the date when the offence in question was committed. Full stop para D bracket. For arriving at this conclusion, the trial court shall be entitled to call for and consider all the relevant documents as well as have the facility of medical checkup of the appellants in a manner known to law. Full stop para E bracket. The report in that behalf shall be submitted in the registry of this court within 4 weeks. Full stop para. List this matter for further consideration along with the reports in the week commencing 31st October 2022. Full stop para. Pursuant to the said order, a report has been received from the Court of First Additional Session Judge, Manwar, District Dhar, Madhya Pradesh, dated 27 August 2022, running into 20 pages along with all the materials, evidence both documentary and oral adduced before it on the basis of which the report was been submitted. Full stop. As per the said report, the applicant's date of birth was found to be conclusively proved as 25th July 2002. Full stop. The date of the incident being 15th December 2017, the appellant was 15 years 4 months and 20 days of age on the date of the incident. Full stop. The operative part of the report is reproduced below para. At the outset, learned senior counsel for the appellant has clarified that for the present he is only pressing the plea of juvenility, and if he fails on that count, would address on the issue of conviction and sentenced Pulsha. Further, based on the said report, learned senior counsel for the appellant submitted firstly that the sentence awarded cannot be given effect to under section 9 bracket 2 of the 2015 Act Pulsha. Secondly, it is submitted that from the date of arrest in December 2017, the appellant has already undergone incarceration of more than 5 years, where under section 18 of the 2015 Act, a juvenile below 16 years, even if convicted for a heinous offense, the maximum sentence that can be awarded is 3 years stay in a special home. Full stop. In view of the above, according to learned senior counsel, the appellant is liable to be released forthwith. Stop.